afternoon and welcome to Have We Got Planning News for You? We hope you've had a great week so far. Thank you very much indeed for joining us. Thank you to our YouTube viewers in the future watching us later on. Don't forget, please, to subscribe to our YouTube channel. I'm Charlie Bannon. Can I start with the by now familiar reminders? Firstly, please do consider making a charity donation either to the NHS Combined Charities Just Giving page or a local charity of your choice. And secondly, please do keep the questions and the banter flowing in the Q&A box. And in particular, please do let us know your questions for our special guest. And that special guest this week is none other than the Lord Carnwath, Robert Carnwath, a Supreme Court Justice, former Supreme Court Justice whose career as a judge in planning cases spanned over 25 years. Robert's planning-related cases in the Supreme Court included Suffolk Coastal on housing land supply and the tilted balance, which Chris was in, HS2 on EIN, SAA, which I was involved in, Champion on habitats, and Sam Smith earlier this year on greenbelt policy. And of course, non-planning cases included the prorogation case last year. Look, Robert, welcome. Thank you for joining us. Perhaps you can tell us where you're calling from. I think you need to unmute yourself, as do a couple of others, where you're calling from. And please tell us, we've chosen Italy as the theme this week, and you've chosen that, and perhaps tell us why.
Well, very nice to see you all. I've looked into some of your programs, and so I'm interested to see what's going to come out of this one. I'm in Notting Hill, sunny Notting Hill, not so sunny, but that's where I've been most of the time since I retired, except for a brief spell in Italy. My wife is Italian. I actually met her in connection with a planning inquiry back in 1971, so it has a certain sort of resonance, though happily she's kept out of that side of my life. But anyway, so Italy is the theme, and I'm drinking Campari soda. So
fantastic. Well, thank you so much for joining us. We're honoured to have you with us. Mary, how are you this evening? You're in the woods once again.
I'm in the woods. I have to say, I'm in the wet woods of Wandsworth today. Hello, everybody. Mary Cook from Town Legal, and in honour of this marvellous occasion, I have chilled a bottle of Prosecco from the lovely shores of Italy. So that's what I should be drinking.
I hope you're not getting withdrawal symptoms from the gin. Chris, the opportunities are endless after your Glaswegian accent last week. You know what you've got to do.
We might just give the accents a miss. We might just do that this time. Yes, I am at home in Hogwarts Castle, and for the Italian theme, I am drinking Moretti. And Presumption is with me, and he's got a poster of his favourite film, The Italian Job.
Italian Job.
Yeah. Charlie, you're only meant to blow the doors off.
Oh, buonasera.
Buonasera, mi dispiace non posso parlare italiano. Ciao, everybody. This is the fedora I bought for my 25th wedding anniversary whilst on Capri. Didn't fit me then, but I wasn't sober when I bought it, so at least it's Italian. This is the scarf from 10 years ago when I watched Italy play Ireland and get absolutely walloped. And I'm drinking some Peroni Libera on the grounds that I'm driving later. So, welcome.
Cheers, Paul. And Sasha, viewers from last week who've been paying attention will be disappointed to know that a leading QC can only afford a single tie.
Charlie, that you can add that. That's number 98 slander you've made against me. Don't ask me where
he's flummoxed.
Yeah, I am actually.
at least he's wearing a tie.
I literally thank you.
Yes,
thank
true.
you, Robert. I finished my re-examination at 5:03. So watching the countdown, I've literally come in. I didn't put an Italian outfit on for my inquiry in case Inspector thought I wasn't giving it the due deference it deserved. But I'm in London, and I am very much looking forward to tonight's episode.
Lovely to see you, Sasha. Well, Charlie Banner from Keating Chambers. You might notice an unfamiliar background. I'm at the house of my, and indeed Robert's very good friend, David Cooper, with David and Julie, with whom I've got a consultation afterwards. We're in the basement, but there's 2 bars of Wi-Fi here. I'm a little bit worried it might go down to 1 bar, but hopefully we'll survive. And I am drinking Negroni. As you'll see, I've already opened it. One of the world's greatest drinks, and also one of the world's most potent. So hopefully I'll still be on my chair by 6 o'clock.
I'm actually amazed they let you in tonight, Bridge. Enjoy it. It's your only 2 hours you'll ever spend.
Absolutely. My shoes will be turning back into a pumpkin and take me back to the West Midlands shortly, I'm sure. Without further ado, first 2 High Court cases this week. And Paul, you're going to deal with that one for us.
Yes, thank you. And in a week that I have succeeded in an appeal for 200 houses in Cheshire East, an appeal for 180,000 square metres of logistics south of Milton Keynes, my colleagues have nominated me to talk about an outbuilding in a Welsh garden. Thanks, guys. And to do so in front of one of the greatest legal minds of our generation. So enjoy, Robert. This is a case called McGaw and Welsh Ministers and Swansea Council. It's a decision of His Honour Judge Jarman, and it's all about Mr. McGaw's desire to have a big house, have an outhouse in his big house in Sketty, which you'll all know is west of Swansea. Mr. McGaw's back garden slopes upwards towards his neighbour's house and ends with a wall. And the issue is, how does Mr. McGaw get a very big outbuilding into that space? Well, in 2017, he made an application for an LDC to put an outbuilding up under PD rights and was not by Mr. Inspector McCoy. And then that was quashed and sent back for reconsideration. And then it came before Mr. Inspector Alwyn Nixon on the 19th of February, who dismissed a written reps appeal. Mr. Nixon, I don't think, was desperately impressed by Mr. McGaw's cunning plan, which, if Rob is available just to put up the illustration, if this works perfectly, and he probably won't. Yeah, if you look on that, that's Mr. McGaw's house on the left. The outbuilding is on the right, and you'll see that the outbuilding has a flat roof close to Mr. McGaw's house and then rises up for something described as a lantern. That lantern is a huge extension and effectively has a greater height than the ground floor of the building, but it's not at the eaves. The eaves are the flat bit. So one can see, you can lose that now, Rob, thank you. You can see how Mr. McGaw has tried to get around the system, and Mr. McGaw failed to get around the system in front of Mr. Inspector Nixon, who said, well, what do I do when I look at how I measure the height? Mr. McGaw got away with the argument that the lantern in the middle of the building, because it's set back from the edge, doesn't count. So he got away with that. Well done, Mr. McGaw. But unfortunately, he cleared the ground before he'd started to build and the anticipation of the first LDC. The argument was before Mr. Inspector Nixon, you look at the existing ground level, not the subsequent ground level. And Mr. Inspector Nixon said, yes, you look at the existing ground level, not the ground level you're gonna fill back to. Unfortunately for Swansea City Council, His Honour Judge Jarman said that that's wrong, and actually concluded that you look at the ground level after it's been put back, or rather after it's been filled. But at paragraph 29 said, but don't worry, because if somebody contrives to create a ground level afterwards, that might not be the case. It's as clear as mud, the sort of mud that Mr. McGaw was trying to build his building upon, and it's an important case which I hope will be in the armoury of everyone that's on this. And I apologise for wasting Lord Carnwath's time with such a minor issue.
Well, he was so unimpressed he disappeared.
I'm sorry.
I love it.
What I should have said at the outset is why I'm wearing the
forgot to mute myself, so you probably heard me having a conversation with my wife. But I'd forgotten how exciting planning cases could be. Thank you.
And our several hundred viewers have just witnessed the peak of Paul's career.
What I have forgotten, Charlie, is to say the reason why I'm wearing a Blackburn rugby shirt is also an Italian link, because their coach is Dino Radici, a friend of mine, who got them promoted from Northwest Division to Northern Premiership. So this is my Italian link as well.
Fantastic. Superb. Mary, you're going to tell us about another High Court case.
No, we're in the Court of Appeal in this case,
Appeal.
and this is a Court of Appeal case. And actually, Sasha talked about this case in Series 1. So this is Lochale Lort Investments Limited, if you remember that, Sasha. So this is an appeal against the judgment of Mrs. Justice Lang, as she then was, because of course she's now been promoted to the Court of Appeal. And this is all about the Norton St. Philip Neighbourhood Plan, which was adopted with several parcels of local green space. And our listeners will know that local green space is a creature of the NPPF, and that once land is identified as local green space, it is treated for development management purposes as if it were greenbelt. Policy 5 of the neighbourhood plan stipulated, and I quote, development on local green space will only be permitted if it enhances the original use and reasons for the designation of the space. Now, you remember that at first instance, the attempt to quash both the designations and the policy itself failed. And in the Court of Appeal, the challenge to Policy 5 was upheld and the appeal was allowed on this ground, but the designations of the land remained lawful. So perhaps it wasn't quite the result that the appellant was looking for, but in a particularly appropriate case, Sasha, that you chose for me this week, in addressing the ground that the designation was unlawful, the appellant took the point that the examiner did not address the policy in NPPF paragraph 101 that local green spaces should be capable of enduring beyond the plan period, rather like the greenbelt, and that the court below was wrong to repair the deficiencies in the examiner's report by applying a presumption in favour of the examiner assuming she must have taken national policy into account even though she didn't mention it. And guess what? Sorry, guess which case, let's get my grammar right. Guess which case the Court of Appeal relied upon and cited? Lord Carnwath in Hopkins Holmes. You've got it. Paragraph 25, where he set out the need for the courts to respect the expertise of specialist inspectors and to start from the presumption that they will have understood the policy framework correctly. The appellant in this case argued that the inspector was appointed by the local planning authority, not the Secretary of State, and didn't have the support of PINs. And the Court of Appeal, I think perhaps unsurprisingly, wouldn't have any of that, and agreed that the presumption was the starting point, but not, of course, that it was irrebuttable. But nonetheless, the appellant was unable to persuade the court that in this particular case, the presumption should be rebutted. And so that part of the appeal failed. But in terms of Policy 5, Richard Ground, QC, who was acting for the appellant, made the point that the policy, which I read out at the beginning, is in fact more restrictive than Greenbelt policy. For example, it didn't make any reference to appropriate development. It didn't permit limited affordable housing, which Greenbelt policy permits. It didn't permit things like outdoor sport or any kind of inappropriate development if very special circumstances were made out. And so, in short, the policy was regarded as not being consistent with the Greenbelt policy. It was more restrictive. It didn't comply with paragraph 101 of the NPPF. And that departure might not have been fatal if it had been a reasoned departure. But no reasons for that departure were given. And so Lord Justice Lewison disagreed with Mrs. Justice Lang, as she then was, on the point that the policy was flexible enough to be read consistently with the NPPF. And the Court of Appeal found that the basic condition test that you have to have regard to national policy had not been followed, and the appeal was allowed. One of many instances, if I may say so, of your judgments being quoted and relied upon by the courts, Robert.
Thanks, Mary. Lord Justice Lewison, one of my favourite currently sitting judges, but I'm probably jinxed it now because I'm in the Court of Appeal twice later this month, and now I'll probably get him and lose. And now I'm going to talk about the first of the two planning. It's not a planning appeal; it's a DCO case this week, and it concerned an application by Esso, the oil company, for an energy company for a development consent order concerning a proposal for a new 97-kilometre steel pipeline to carry aviation fuel. Goodness, how I miss the smell of that. From the Fawley oil refinery near Southampton to Esso's West London terminal near London Heathrow Airport. I can't quite work out if the team gave me this case to talk about because the pipeline ran between the location of two of the developments I've worked on recently, Fawley Waterside and Heathrow, or because the decision's nearly 900 pages long. Thanks for that, guys.
It's definitely the latter.
Anyway, the pipeline was to replace the existing 50-year-old pipeline that currently runs between the Fawley oil refinery and Heathrow, which is falling apart or about to fall apart. And the alternative to a new pipe was 100 lorry movements a day between the refinery and Heathrow. That was the appellant's case. There were a whole series of controversial issues relating to the alleged impacts, mainly directed at the construction process. And in relation to all but one, the PIN's examining authority found that there had been no harm and or that the issues were of neutral weight and planning balance, and the Secretary of State for Bays agreed. The one aspect in which the significant harm was identified was in relation to landscape. You might wonder, well, how could an underground pipeline cause permanent harm to landscape? Well, it was because of the need to remove trees in the process of digging trenches to lay the pipe. This included the need to remove 28 trees in the Queen Elizabeth Park in Farnborough, which triggered a petition with over 6,000 signatures. And Esso said a different route or a trenchless construction process wouldn't be feasible. The Secretary of State agreed, granting the DCO in accordance with the PIN's recommendation. And to my mind, the most notable feature of the decision was that at every stage of the analysis, the presumption in favour of oil pipelines under the relevant national policy statements, EN1 and EN4, combined with the recognition in those statements of the benefits of such facilities, won the argument. That's what outweighed the impact on the trees and the landscape. That's what generated very special circumstances for the greenbelt elements of the pipe. And that was the cornerstone of the compelling case of the public interest, the compulsory purchase aspect. And indeed, fundamental to this was a finding that aviation fuel was an oil product within the meaning of the national policy statements, which was a precursor to finding that the development benefited from the statements. And I think what all this shows is two things. Firstly, it shows the fundamental importance of national policy statements to the DCO regime and how many of the critical debates and issues are resolved wholly or mainly at the NPS stage. And by the time the project consent is sought through the DCO application, the pass may already have been sold and objectors may find there's little, if any, opportunity for them to resist the principle of development. And I think it's little wonder in light of that there seems, to me at least, to be a growing trend of challenges to new national policy statements, such as the airports one, as well as requests to government to review existing NPSs in an attempt to sort of procure a judicial review claim if they say no. And the second thing is the case is a pretty good advert for the DCO process, with a caveat: 97 kilometres of pipeline, including in the South Downs National Park and in Greenbelt, and only one unresolved adverse impact which didn't outweigh the scheme's benefits and support from the NPS. The price of that, the caveat, is 400 pages of actual decision, 800 pages if you include the DCO itself. And that doubtless that reflects many more reams of assessment work undertaken by Esso in the run-up to the DCO application and indeed during the application. And that highlights to my mind that in all the excitement that everybody is engaged in currently over the proposed reforms to the normal conventional planning system under the white paper, we mustn't lose sight of potential opportunities to sharpen up the DCO process to make it a little less onerous, particularly given we're meant to be having, as the PM has said, an infrastructure revolution, to try and make that process less cumbersome and less expensive. So that's my contribution. And now, Sasha, you're going to tell us about a housing appeal that's been allowed.
I am, and I know we've been slightly hard on the inspectorate in the recent past and inspectors, but I want to really have a shout out for Zoe Reagan, because I'm going to talk to you about a planning appeal for 128 affordable houses, 100% affordable housing scheme. And this is a really powerful decision, absolutely spot on. I mean, a lot of our viewers will be fed up of Chris and I particularly banging the drum about the housing crisis, but my goodness, it's right. This is a case where local authority is significantly behind the provision of affordable housing, and yet they refuse an application for 100% affordable housing. Not only that, They then argue that effectively their shortfall of affordable housing over the planned period should be dealt with on the Liverpool basis, i.e. over a planned period. So a housing need, affordable housing need that they failed to meet in 2013 onwards, they say they should be allowed to go up to 2031 to meet it. Well, let's just think about that. In reality, that is real people on a housing list waiting for housing. And the shortfall, effectively, there were over 2,000 people. There were 2,000 people in East Staffordshire waiting for homes in 2020, which is pretty sobering. So what we have here, of course, the council throw the kitchen sink at defending the appeal, and we have an extraordinarily insightful, in my judgment, and right decision to grant consent on the basis that, notwithstanding a breach on the face of it of the development plan, the need for affordable housing was so significant and so weighty it should outweigh, and it's a classic example of another material consideration outweighing a development plan. So I really do think that it's a really exciting, frankly, decision in the provision of affordable housing, because it's a classic case where council sought to resist it and inspectors had the foresight to see that actually it was so weighty as to put aside the development plan. So here, and a shout out to Chris's colleague, Thea Osmond-Smith, for getting this consent through. Absolutely superb. So,
and congratulations, Thea. Now, over to you, Chris. You're going to lead the discussion with Robert. So fire away with your questions.
Yes, thank you very much, Charlie. Well, Robert, good afternoon. I have to say, I've had two career-defining moments up to this point. The first was appearing in the Supreme Court, where you seemed to ask me a lot of questions, and now it's the other way around. Many of our viewers will know of your judgment in Hopkins Homes, also known as Richborough Estates, and in 2017, which has become, as Mary has hinted, the most widely cited planning case of the last decade, even though it was only decided 3 years ago. And not surprisingly, not only did it deal with 5-year land supply and the presumption, but it also dealt with the status of the MPPF, how the court should approach inspectors' decisions, as Mary has said, and how decision makers should treat plans which aren't based on up-to-date housing numbers, which is such a common issue that the case has huge significance. And that's why it's cited not just in the courts, it's cited in all our appeal submissions and evidence. But and of course there's many other cases, but that is just the final stages of your career, lasting, as Charlie said, 50 years, including 26 years at the planning bar, including acting for the Prince of Wales, reviewing the law on enforcement, leading to a whole series of legislative changes. In 1994, appointed a High Court judge in the Chancery Division, whilst also then acting as chairman of the Law Commission, which reviews all areas of law, then promoted to the Court of Appeal in 2002, then acting as the first senior president of tribunals from 2007, and then in 2011, appointed to the highest court of the land, the Supreme Court. What an extraordinary career, a truly extraordinary career. You're one of ours because you're a planner at heart. But it all began when you were called to the Middle Temple in 1968. And can I start there, if I may, and say, what led you to being interested in planning? You've got to take yourself off mute.
I was going to say I was rendered speechless by your introduction, but well, I didn't really know anything about planning in 1968. What happened was my first pupillage was in company chambers in Lincoln's Inn. My second pupillage was in family chambers in Queen Elizabeth Buildings. And I think by mutual agreement, we decided that neither of those was really for me, or anyway, not for me. And so I was then told there was a chance to go what was then called two-paper buildings, since landmark chambers, but then two-paper buildings. And I was told that there was an opportunity to do building contract work with Sir Derek Walker-Smith, who was the head of the chambers. And for lack of anything better, I thought I'd better take that. But in fact, when I got there, it turned out that was the last thing anyone wanted me to do. And I was sent off to Hastings, where they were having a Town Development Act inquiry in which George Dobrin QC was acting for, I think, the objectors. And so I got to know George, who became one of my sort of mentors. And I also heard about planning, and then I seemed to sort of do that for the next 10 years or so. It wasn't, it was a steep learning curve, but I thought it was very interesting because it combined sort of law and people and politics and landscape and environment, all sorts of things which I thought were a good mix. So that's how it started.
Well, I couldn't agree more. I think we'd all agree with that. Just we feel completely privileged to be in this particular area of the law. Now, during your time at the bar, you were for a while, 6 years, I think, the Attorney General for the Prince of Wales. Can I ask you why you think you were selected for that task?
Well, you may want to know what the task involves, but actually one of the oldest offices in the country, going back to the 14th century when the Prince was going off to fight wars in France and needed someone to run his affairs in this country. But its role has changed slightly since then. And I think when I was, it was really my predecessor was Andrew Morritt, who I'd got to know when I was doing sort of tax cases and things. And he, I think he thought the Prince needed someone who knew something about planning, because it was just when he was beginning to get interested in things, in particular Poundbury, of course, which became a big issue. And so, and I think the other thing, which was pure chance, the great friend of mine, Marcus Binney, who some of you may know as the founder of Save Britain's Heritage, had started a magazine called Landscape. He had been editor of Country Life, but he had a bit of a bust up with them and set up his own magazine, for which I wrote a legal column. And Marcus had somehow got the Prince to subscribe to his magazine. And so he was vaguely aware of me as someone who knew about the law. And I think that combination meant I got that particular post, which was actually fascinating.
Yeah, fascinating to work with him and for him. Now, the first that I came across your name was doing a master's dissertation at King's College into planning and planning enforcement. The Carnwath report was a seminal report into what was a very, very complex and difficult area, planning enforcement, leading to a whole series of changes which have endured the test of time, because we have still all that you recommended, planning contravention notices and planning injunctions in particular. But can I just ask you how that came about? How did you get asked to effectively review and then lead to significant changes to the legislation?
Well, like most things I've done in the law, it sort of came by chance. It was 1988. I was a relatively junior silk. You know, I was still at the stage when one did sort of enforcement cases, both for and against local authorities. And I was in the Court of Appeal doing an enforcement appeal case called Thrasivulu, which some of you may have heard of. Yep. Anyway, there was someone on I was acting against the Secretary of State, but there was a lawyer behind the Secretary of State's counsel, I can't remember who it was, who I had met before. And at the end of the case, he said, could I come and have a word with you? And I said, okay, yeah. And he said, look, you know something about enforcement. I've been asked by the Secretary of State, Nicholas Ridley, to do something about enforcement because he's very worried about sort of the Shire counties and gypsies and the Green Belt and things like that. And he wants a quick solution, which is not going to cost him too much. And so I said, well, why don't you get a sort of youngish planning silk who does some enforcement work to write a quick report on it. Anyway, so 3 weeks later, I get a letter from Nicholas Ridley, Secretary of State, saying, would I do a report on planning enforcement? But it had to be finished by, I mean, this was in August, it had to be finished by January. So I did.
And it led to a whole series of changes.
Yes, I mean, it was interesting because I was allocated a very good young civil servant from the department, and I worked with him during the course of September to sort of do a consultation paper. I mean, I had a pretty good idea of what I thought was wrong with the system, but we did a series of questions and went out a questionnaire. I then, in fact, as it happened, I'd been instructed in a case in Hong Kong, which took me up most of the autumn. So I left my unfortunate civil servant struggling with the consultation responses. And I came back at the end of the year and wrote the report in January and February, in fact. But in fact, there was quite a consensus. I mean, the great advantage was that the consultation produced some very good responses from local authorities. I mean, unfortunately, contraveners of planning aren't very good at responding to consultation papers, but and so, you know, it was quite easy to draw a consensus from that. And, you know, well, you see in the result, and in due course, the government took it on board, and we had the 1991 Act.
They
so
did. They certainly did. The government listening to a young silk and an ambitious civil servant. That sounds like a good combination. Now, the number one thing that everybody has been asking us this week about your views on is the new planning white paper. Lots of people who know that you were going to be a guest on the show want to know your perspective on this. So if I can, from your long perspective on the planning system, what has been your experience of attempts to reform it in the past, and how, in that context, do you see the changes proposed in the white paper in the current planning white paper?
Well, I've thought about this. You warned me that this was coming. I mean, the truth of the matter is that after 50 years in this game, one becomes a bit jaded. You know, I've seen a lot of attempts at reform. And I came in 1970 when we had just had the reforms of the 1968 Act, which brought in the structure plan and local plan system, which, you know, I think was pretty good, and we certainly did at the time. We then, oh dear, my wife is bringing me a scones. That's very. The great thing about having an Italian wife, she's always looks after one's food requirements.
Oh, stop it.
Brilliant.
Where was I? Oh, it's jaded. And then in the sort of 70s, we had you've probably forgotten about this, that we had a Labour government which brought in the Community Land Act. And so we had that great excitement. And that never really got off the ground because we then had Mrs. Thatcher. And most of the 80s were taken up with reforming and attacking local government and abolishing the GLC and things like that. So there's been lots and lots of things. And so this time round, I mean, to be honest with you, I haven't been actively involved in the planning system for 25 years. I see the cases that come to us. So I'm not in a position to make detailed comments. I mean, I have great respect for the advisory team. I mean, Christopher Gatkowski, Kit Kat, to you and me, was my pupil. He's done pretty well. I feel proud of him. And, you know, he made a convincing case on your show a little while ago, and you were very deferential to him, I thought. And, you know, Stuart Lipton, I used to work with, and I think a tremendous experience. And they, you know, so I pay respect to that. On the other side, I mean, Charlie's mentioned he's got David Cooper there somewhere looking over his shoulder. Now, David is a truly veteran solicitor who's done more of these planning cases than almost any of us. He first instructed me in 1973 on a housing case. And I've seen a scathing critique by him of the white paper, particularly on the housing side, which he thinks is never going to work. So, I mean, I was rather cross with the forward by the Prime Minister, which is way over the top. I mean, whatever else you think about it, there simply isn't a case for, what, as he says, levelling the foundations and building from the ground up a wholly new planning system for England. I mean, that's never been a sensible way to approach law reform. I can't think of a single area in which that has been thought to be a sensible thing to do. And indeed, the paper itself doesn't make a case for doing so, and I don't think it does actually. You know, I think our system on a whole has been very resilient over the 70 years, certainly the 50 years I've known it, and it's allowed for substantial growth, economic development, while on the whole protecting our countryside and our built environment. So whatever you do, you want to sort of build on what you've got. I think I think KitKat made a good case, I thought, for removing some of the clutter, as it seemed to me. I mean, I'm not familiar with this, but it does sound as if the whole planning thing has got rather cluttered up, and you could simplify that. I'm sure that's a good idea. But I was interested, Paul Tucker, I think, said one was really sort of taking it back to when he started in planning. And I could go back rather before that, but I did have a sense of deja vu, because back in about 2000, when I was chairman of the Law Commission, I was summoned to a meeting with Charlie Faulkner, who was then the Minister of Planning. And we were told that he wanted to have a fundamental reform of the planning system. And he called in a group of us who were supposed to know something about it. And I can't remember who else was there. I think Malcolm Grant was one of them. But anyway, we said basically we didn't think there was a need for a fundamental shake-up of the planning system. We thought on the whole it worked pretty well, but you needed to get on with completing the development plans. And you needed to do something about Section 106 agreements, which I think were a bit of a muddle. And it needed more resources. But anyway, not to be deterred, they decided they were going to go ahead with them. I think Charlie then moved on to the Home Office, and someone else was left with the task of trying to put together a fundamental reform. Yes. And they produced a green paper in 2001 called Planning, Delivering a Fundamental Change. And the justification for that was said to be that the planning system is often rules-driven, reactive as opposed to proactive, over-complex, unpredictable, lacking in adequate community engagement, under-resourced, and not user-friendly. And it was suggested that the way to deal with that was to replace local plans and development plans with local development frameworks, which could, quote, be drawn up in months and would set out basic criteria for acceptable development. Well, I'm not quite sure what happened. I also went back to Law Commission work and I wasn't involved, but I was interested to see that there was a House of Commons committee report by the House of Commons Transport Local Government Committee into the proposals, and they were very, very critical indeed. And I'll just read what they said in the conclusions. Can I go on with this?
Yes,
or?
Because I think there's some interesting observations there.
Well, they said of the they said the Green Paper has been quick to spot, and in our view, in some cases, exaggerate the problems with the current system, but has played down the strengths of the existing practices, and so on. And it says the government's radical reforms are in danger of spawning a new generation of swampies. You probably it would take at least 5 years to establish a new system. The government has been quick to complain about the length of time taken by local authorities to implement the unexceptional obligation of preparing an authority-wide plan, yet retains an incompatible belief in their ability to reinvent quickly the entire forward planning process at local level. There are already indications of reluctance by local authorities to keep their policies up to date, and a hiatus is virtually inevitable as authorities make up the details of the government's new system as they start to apply it. There's a substantial price to pay in the transition for any new procedures, only worth paying if the resulting framework is a substantial improvement over the existing one. We have found little evidence that it would be. We conclude that the government's proposals are unworkable as a whole. And then it went on. The committee was astonished by the lack of attention to the most obvious problem facing the delivery of an effective planning service, namely its under-resourcing. there was a shortage of professional and experienced planning staff in most local authorities, low morale and a recruitment problem. Ministers' obsession with shaming authorities with poor performances, measured largely in terms of speed rather than quality of decisions, has no doubt contributed to this. Meanwhile, local authorities divert money away from planning to other more politically attractive uses. Now, I mean, it's worth studying that report. Now, what I don't know, and I haven't bothered to try and follow, but it'd be interesting to do, is to what fared when what became the 2004 Act went through Parliament, and to what extent those criticisms were taken on board. But I have an awful suspicion from the discussion I heard with KitKat that the problems which now seem to be pulling down the whole system are in fact largely the result of so-called improvements which were brought in with no doubt the best of intentions in 2004.
Yes.
So I think that's all I can usefully say about it.
Well, you know, that's probably the most useful thing that I've heard, which is let's look back, let's look at what happened last time. There was a plan to overhaul the system, and those words that you've just highlighted about it's not as bad as people are making out, and the main issue is the lack of resources for local authorities. I think I'll be stapling that to my response on the white paper, that paper that you've just read out, because it does seem to be entirely relevant now, entirely prescient as well. Now, just away from the detail of the white paper, I do have to ask you, a long-running rumour at the planning bar has been the suggestion that you declined the first invitation you were given to be a High Court judge because it was on the Queen's Bench division, and that meant you'd be posted all around the country and away from your beloved Bart Choir in London. And so you waited until you got a position in the Chancery division where you'd spend more time in London. Is there any truth in that rumour?
I don't know where you got that idea from. Entirely appropriate for me to have that as a relevant factor in that particular discussion.
Of your planning judgment.
One of the results of being in the Chancery division was that I stayed in London, and I've been able to sing in the Bach Choir ever since until lockdown.
Yes, yes, and may that soon return whenever that is possible. Now, of your planning judgments in the Supreme Court, which are the ones that most of our audience will be very, very familiar with, can I ask you, which did you find the most challenging?
Well, I mean, they're all quite challenging because, I mean, in a funny way, the cases are the most difficult, the ones you know most about, because I'm conscious of all you chaps out there who are going to be criticizing and reviewing everything I say. So, but I think probably the one you mentioned, the Hopkins one, was the most challenging. I mean, firstly, it was in a very important area, and I was very conscious that the National Planning Policy Framework had started out with the best of intentions of simplifying things, and somehow that had failed. So I was very anxious, if I could, to try and cut through that. On the other hand, I was faced with a very strong judgment of Keith Lindblom in the Court of Appeal, which sort of tried to bring together the threads of another number of conflicting judgments from lower courts. And so I was, one differs from him at one's peril. And also I was actually differing, as you probably remember, from all the submissions of counsel who appeared in front of me. I mean, I didn't in the end, it seemed to me rather simpler than they were all saying. But of course, they included the representative of the Secretary of State, who was supposed to know what his own policy meant. But I had the feeling that the Secretary of State had lost confidence in the simplicity of his original policy and been sort of diverted by too many judgments. And I think the other factor, which you probably were not aware of, is that unusually we had 3 judges in the court who knew something about planning. I mean, we had 2 Scotsmen, Lord Gill and Lord Hodge, both of whom had a lot of experience of planning. And so it was particularly important to sort of to reach a composite view. And I don't think I'm revealing any secrets if I say that we actually, the sort of key paragraphs were quite subject to a lot of discussion and revision.
I have to say, you mentioned about the simplicity of it. I think it is a brilliantly clear and elegant judgment after all that had gone before. 5 High Court cases, lots of people, all about what does the phrase relevant policies for the supply of housing. And your judgment is, I know you don't want me to say this, but it is absolutely crystal clear. But my favourite line in it is that one, after hearing 10 barristers over 2 days, the judgment includes the best put down I've ever heard in a legal judgment, but the most polite as well, which was, unaided by legal arguments, I would have thought the meaning of the phrase was reasonably clear, which is largely translated as if you were to ask a 10-year-old, what are the relevant policies for the supply of housing, they'd probably have given you a straight answer.
I'm sorry, that was rather offensive.
No, it was brilliant. It was brilliant, and we've all loved it. Can I just ask you briefly about the Dill case? I mean, fascinating case. We've covered it on this show. About the urns, you must have found that interesting, particularly given your previous work with Save Britain's Heritage. Yes,
I mean, that was a challenging one. And of course, it was my last planning case, and I had David Olvin to deal with, who's quite difficult to put down. And he's a very powerful, I mean, put down in the best possible sense.
Yeah, very clever.
and I was very anxious to find a sort of delicate, as it turned out, it was rather a frustrating case because in fact it turned on whether the inspector should have dealt with the issue. And we weren't in the end able to sort of get to grips with whether the urn was a building or wasn't a building. And I'll be fascinated to find out if that issue has ever decided what the answer is. But, I think that whole question of how you define building in the context of listed building legislation is very difficult indeed.
My last question is just what advice you would give, because I know there's a few of them listening, you would give to those thinking about becoming a judge, a young aspiring judge. Any guidance that you would give?
Well, get on with it. I think, I mean, when I became a judge, I was invited. In fact, the first time I was invited, I didn't take it for various reasons, but one which carried more conviction with the Lord Chancellor was that I was involved in a quite heavy litigation in Hong Kong, which I really needed to see out. But otherwise, when I became a judge, it was a wonderful change. It's a wonderful opportunity because if you've done planning or anything for 25 years, to be able to move on to something which is similar, which uses your skills, but it actually involves quite different techniques, is a great privilege. And I've been very lucky. So, I get on with it, but I mean, it's hard work, but then enjoyable work.
Excellent. Now, those are my questions. I know each of the panelists has one, so I'm going to begin with Mary. Your question for Robert.
Thank you very much. My question is about environmental protection in a post-Brexit world. I know you've been very involved in UK for long periods of your career. What, if any, concerns do you have about environmental protection in a post-Brexit world?
Well, I think probably less than in relation to some areas of current government policy. I think the one thing that has been consistent in government policy over the last 2 years in the Brexit context is their determination to retain the environmental controls. I mean, the difficulty is how you do that. And I think the environmental bill has a lot to argue about, not least the role of the Office of Environmental Protection and how you can replicate, if at all, the functions of the European Commission. But I think in principle, the government's heart is in the right place as far as I can ascertain it. And so I'm reasonably optimistic that once that bill comes back to Parliament, as I hope it will fairly soon, it will produce a reasonably strong framework.
Charlie, your question next.
Thanks, Simon. Before I ask my question, Simon Stanion, who I think was Mr. Dill's lawyer, has posted in the Q&A. In case you didn't know, Robert, the local authority withdrew their enforcement notice after your judgment, in case you wanted to know what happened next. So that is.
Yeah. But I must say, I tried to encourage that, but it does mean we'll never know whether that was.
No, quite. So it's sort of, It sort of doesn't really tell you the answer on one level. So my question, Robert, is this: as the lawyers amongst the viewers will know, but there's a lot of non-lawyers, to bear that in mind. You were the first senior president of tribunals, the new consolidated tribunal system. Indeed, you've said to us previously it was one of your many career highlights. So my question is, in that position, did you ever contemplate bringing in PINS-related planning and environmental appeals into the new tribunal system? And if you did, what was your thinking about that?
That's an interesting question, which I think is still possibly a live question. I mean, I did, yes. The answer is when we were looking at the scope of the tribunal system, I've always been interested in the idea of creating a sort of land and in planning and environment tribunal, sort of along the lines of the New South Wales model court. In fact, if you look at my 1989 report on enforcement, I floated the idea then, and it was then actually picked up by Harry Wolff in his maiden speech in the Lords, and Richard McCrory and I sort of worked on the idea. And so when I became senior president of tribunals, I thought, yippee, here's a chance. And I always thought that an obvious part of that would be the inspectorate, which is in all but name a tribunal, in the sense that it's moved away from when I started it. A lot of the cases were decided by the Secretary of State, but that had sort of ceased to be pretty irrelevant. But it was never going to be practical, because there was quite enough to be taken on board in creating the new system without that. And I think the inspectorate had developed their own sort of independence, and that was respected by the public. And so I think the feeling was it would have been a sort of change which wasn't needed or appropriate. What I saw as actually a possible advantage was indeed in sort of cases of interpretation. It seemed to me that in a tribunal system, you could have had, instead of the planning court, you had an upper tribunal planning, which could have had senior inspectors sitting with a High Court judge, so that you could actually look at these issues of interpretation in a rather broader way than you do with simply a High Court. And so that was something which I thought was a possibility. I think it's still a possibility, in a sense, as part of the if the sort of judicial review panel ever gets a chance to look at things in any depth, that's would be a possible idea.
Fascinating. Thank you very much. I must finally just say, my host has given me this. I don't know whether you gave it to him, but it's a wonderful quote. A good lawyer knows the law, a great lawyer knows the judge.
I'm happy to say that didn't affect my judgment when.
No, I'm sure it did. No, they're out of time. Thank you. That was a really interesting answer. Thank you.
Paul, your question. Oh, you're on mute.
I do love this technology. Thank you, Chris. Robert, firstly, the green paper, sorry, the House of Commons response to the green paper that you made reference to, I think we'll put on our website, because there are so many gems in there. It's extraordinary. It's almost like a work of prophecy as much as anything else. Things like where elected assemblies are not set up, the present system should remain. As presently conceived, the local development framework is likely to be too difficult for professionals to understand, let alone the community at large. And to be blunt, Chris, myself and the others have made a very nice living out of the confusion of the non-plan-led system for the last 15 years. But there we are. So going back to basics will be welcome. So my question, Robert, is a simple one. You've got experience both from the Carnwath report, from your time as a law commissioner between 1999 and 2002, and you've seen any number of green papers and white papers come and go. So I'm interested in your view as to how you should go about reforming the law. Is it the approach of the white paper of the panel of experts, or is it the Law Commission thinking very carefully and proposing legislation? What's your thoughts about how we do this?
Well, it's not rocket science. We've had a Law Commission for some time now, and it has a very well established way of doing things, which is to look at the problem, to try and see what's good about it and what's not good about it, to look at the evidence, to do some comparative study of other systems which might be doing it better, prepare a consultation paper, put it out and find out what people think. And then in the light of that, put together your proposal. You know, that's, and in a very simplified way, that's what I did with the enforcement. You know, I don't actually, I don't understand what this latest thing is. It calls itself a white paper, but it clearly isn't a white paper in the sense which I knew. It would be a statement of settled government policy. It seems to be asking questions, but I mean, the first question seems just silly. I mean, you know, what are your 3 words to describe the system? You know, with respect, I mean, I know Kit Kat liked it, but I thought it's pretty silly. Anyway, you know, I can expand, but I mean, everyone knows how you do a law reform project.
Yeah, and do it properly with the Law Commission. Thank you, Chris.
Sasha, your question.
Yes, thank you. Robert, you've mentioned the independent review on administrative law, which Lord Fawkes is currently undertaking. And obviously in planning, the judicial review of grants of consents is very important. And one of the things, key elements of evidence they want is how does the current system balance the rights of individuals and citizens against the powers of government to act what's said, carrying on the business of government. In your experience, where do you think currently the balance lies, in favour of the citizen or the government, or is it about right?
I don't really have a view on that. I mean, I find that, I mean, this again is a very frustrating exercise. I mean, I know Edward Fawkes quite well, and I have great respect for him as a lawyer. And, but his, you know, he's not a, as far as I know, he's not a judicial review specialist, but he's got experience of government. But I mean, he was the one actually who was responsible for seeing the 2015 reforms through Parliament, which included the setting up of the planning court. And as far as I know, the planning court has been quite a success. I think I have no reason to think it hasn't. And so I'd have thought in that context, it'd be a good idea to sort of let it settle down and see what, if anything's wrong with it, and study that. But as to whether the system is, the balance is drawn right or wrong, I think it's a very difficult judgment to make. One tries to deal with the issues according to the law as they come. I don't think any of the judges dealing with it, and they're very experienced lot, does other than to look at the merits of the case.
Yeah. Sasha, thank you very much. Now, I can't leave you, Robert, without just reminding myself of the letter that you sent out 3 days before the Hopkins Home case started. All the barristers were busy preparing the case. I'm just going to ask Rob, who's our IT guy, to bring the letter up on the screen if he can. And I don't know if you can see that. Can everybody see that? This was the letter that we received, which is obviously dealing with the law, but basically what it's saying is there actually any legal foundation for having the MPPF at all? Now, Harry Philpott acted for the Secretary of State. I doubt very much that Harry got any sleep for probably 72 hours. The best answer came from Christopher Lockhart Mummery, which I think was the answer that, is the answer adopted in the judgment, which is to say it can be inferred from the other legislation. But it certainly set the hairs running. There's no doubt about that. You disagreed quite clearly there in this letter about the fact that Lord Justice Laws had suggested the MPPF was based on prerogative power, which everybody now knows about following the Brexit case. You were pretty certain, weren't you, that it wasn't based on prerogative power?
Yes, I mean, one of the joys of being a judge is that you can make the counsel's life slightly difficult sometimes. But I mean, that was a serious question because I'd always wondered about that. I mean, there used to be something called the Minister of Town and Country Planning Act, which clearly gave the minister the relevant powers, but that was abolished when they set up the Secretary of State back in 1970. And I was always puzzled about what the answer was. And then I was a bit surprised when my late lamented and eminent colleague, John Laws, came up with the suggestion that it was a prerogative power. And, I mean, I didn't think that could be right, and particularly, given that planning is entirely statute made. And as you say, we'd had quite a lot of discussion of prerogatives in the Brexit case. So I thought, it'd be a good chance. Well, I thought we ought to find out what it was, as part of the process. And as you say, Christopher Lockhart-Mummery came up with what to me was a wholly convincing answer.
Yeah. Yeah, well,
sorry to those who lost sleep over it.
Yeah. I know Harry's watching as well. I mean, you talk about all these legislative changes coming in, but that might be one to include money. It might be to put the MPPF on a statutory footing. Perhaps not everything needs to change. Just check the fundamentals. It has been a complete and utter pleasure and privilege, undoubtedly, to speak to you and to have your perspective on all these issues, which is absolutely invaluable. I do hope you will respond to the white paper if you feel able to, because there's an awful lot of what you've said that an awful lot of people making the decision should actually listen to. Thank you very, very much indeed.
Thank you.
Thank you very much, and thank you from me too. I remember I used to have a room opposite Christopher Lockhart-Mummery, my very good friend, who I miss a lot, having not seen him since lockdown. And I remember him coming into my room when that letter was received and chatting with him. And I remember saying, if it was a prerogative power, then technically Henry VIII, as he was between chopping the heads off wife number 6 and wife number 7, would have been contemplating, should I exercise my power to regulate national planning policy? Because technically it would have existed from there.
But I mean, as I pointed out in that case, the earliest case on the prerogative back in the early 17th century was indeed a case about planning.
Yes.
And about sort of trying to prevent ribbon. The monarch was sensibly trying to prevent ribbon development around London. And Edward Cook said, well, bad luck, you haven't got that power. So
absolutely.
That was rather more useful than cutting off people's heads.
Absolutely. Yes, you might hope so, at least.
Very, very, very early. Charlie, can I just say, Henry VIII, he only had 6 wives, so you know.
I went to school in Birmingham, not Worcester, Chris. So
okay, all right.
There we are. Reveal my true roots. Now we've got champion of the week, Sasha. Your tie designer for managing to make all your ties look exactly the same colour.
No, well, actually, Charlie, this is a Cambridge blue. I just wanted to assert the superiority of the
tiddlywinks.
Yeah. I just wanted to, my champ of the week, actually, having been in an inquiry via Teams, I wanted to actually commend the inspectors who are doing this and keeping the process going, the actual inspectors on the ground, because every day there are problems, the internet going in and out, people dropping off, people dropping in, all sorts of things. But generally I've found, and I'm sure this is the same for the panel, that inspectors are really trying to do business and get it done. So I commend them.
And Sasha, isn't it right, actually, that they've had the first blended event this week with Jonathan Easton? That's
absolutely right. In Doncaster, isn't it?
Yeah, Doncaster. And Inspector William Fieldhouse has said that he's found it a very effective way of doing it. Well done for Jonathan. Well done to Doncaster Council. Well done to Inspector Fieldhouse. Well done to the Inspectorate, because we all want to be back in a room soon.
And now Mr. Nasty Paul is going to give the judge the nudge of the week.
Yeah, I'm going to give nudge of the week, which is to Chris, but just stealing my thunder then. I was going to twist the Doncaster experience into a negative by saying, shouldn't everybody else in the examinations think of doing exactly the same? Because it works in a large space. It works. The inspectorate are willing to do it, and it works. So yes, my nudge of the week, Chris.
I thought it was champion.
I'm going to give you the good news. So the good news is our next episode is going to feature another judge, but not a constitutional judge, but a celebrity judge, Judge Rinder from the telly, who has been, amongst other things, on one of the dancing shows. I think it was Strictly Come Dancing. It might have been the nice one. Those who watch it can tell. Now, Judge Rinder, why is Robert Rinder coming on the show? Well, he's coming on the show because he's become recently an ambassador for Shelter. And he feels, as do, I think it's fair to say, all of us, very strongly about the housing crisis and wants to talk to us about the role that the planning system can play in meeting the housing crisis. So we're really looking forward to having our first, no offence to our existing guests, our first proper television celebrity joining us. That's going to be, however, not next week. It's going to be on the 5th of November, Bonfire Night. We're taking a 2-week break now, given half term. Not that there's anything you can really do with half term, given the current state of play nationally, but we're going to take that time off, and we will come back on Thursday, the 5th of November, for a continuation of season 2 through till mid-December. We've got some other guests who are already lined up, which we're going to keep to ourselves for now, but some really interesting people for the second half of the show too. But in the meantime, can I reiterate my thanks to Robert for that really fascinating insight. And
Ollie, can you just make, I mean, that was a tour de force.
Really was, actually. I mean, and particularly for someone like me, I've only been doing this for 15 or 16 years, to get that.
Oh, you're bragging again about your age.
I was invited, as you know, because we were all invited with the younger planners, and I thought by implication that's suggesting I'm not a younger planner anymore, but still to have that sort of top of the mountain analysis from you, Robert, as to and putting the current proposal into perspective was really fascinating, and I'm sure we had lots of comments saying that too. Please don't forget your donation to the NHS or a charity of your choice. Please don't forget also to email us with suggestions for things we might cover in our return episode in a couple of weeks or 3 weeks' time. Have a good next 2 weeks if that's possible. It may not be given the state of the news, but I hope you can make the most of it. Take care, stay safe, and we'll see you on Bonfire Night, the 5th of November. Cheers.
Ciao.
Good night. Ciao.